Good morning, everyone. Welcome to the third session of the Bishkek Arbitration Days. This panel is dedicated to the impact of COVID-19 on contracts. Thank you very much for joining us today. My name is Shirin Gurdova. I'm an arbitration practitioner based in Paris, and it's my utmost pleasure to moderate this panel today. So, what is the impact of COVID-19 on contractual obligations? What is its impact on day-to-day operations of legal departments? Can anti-pandemic measures taken by governments be considered a force majeure, and why? All these questions will be answered by our speakers today. I would like to introduce them now. Our first speaker is Dr. Dmitry Davydenko. He's an associate professor at the Moscow State Institute of International Relations. He's an executive secretary of the Expert Council under the ICC Russia Commission on Arbitration. He's also the director of the CIS Arbitration Forum. He has been practicing law for more than 15 years, and he has been involved in many Russian and cross-border disputes. He's an author of over 80 research papers and 2 books. He has been listed among the best arbitration practitioners in Russia for 3 consecutive years between 2017 and 2019 by Who's Who Legal and Global Arbitration Review. Our second speaker is Ella Omelchenko. Ella is a counsel at Clifford Chance's office in Moscow. She specializes in all aspects of corporate transactions, including real estate, oil and gas, energy, and infrastructure. She also advises on real estate development with a special focus on construction. She has extensive experience in all aspects of foreign investment in real estate. Our next speaker is Alexander Akhmetbekov. Alexander is a corporate counsel in ultra-high net worth individual family office. He has almost 20 years of experience in Russian and international law firms as well as investment funds. And finally, let me introduce Tomas Vail. Tomas is the founder of Vail Dispute Resolution. He's an arbitrator and arbitration practitioner based in London. He has over 10 years of arbitration experience. He's native of both English and Russian. He is recognized as a leading arbitration practitioner by Who's Who Legal and Legal 500 UK. Tomas has represented clients throughout the world, most frequently in Russia and the Commonwealth of Independent States, Eastern Europe, and Africa. He has particular experience of the petroleum and mining industries. And I also would like to thank the organizers, Putilin Sipol and the American University of Central Asia, for organizing this wonderful event. Now, without further delay, I would like to give the floor to Dmitry Davydenko. He will review the case law on force majeure and hardship in international commercial contracts. Dmitry, the floor is yours.
My task today is to make a brief overview of the existing case law on such important legal doctrines as force majeure and hardship. Now I will share with you my presentation, which was prepared especially for this purpose. So, as a general remark, clearly this pandemic results in a large-scale economic turbulence, which has the following consequence. One of the consequences is that debtors in international contracts will likely frequently rely or invoke the impossibility to perform the contract, to, well, say that the performance of the contract becomes unexpectedly burdensome because of the restrictions imposed on trade and movement of persons and goods. Economic crisis, price fluctuations, and similar events may also become a frequent argument in disputes caused by pandemic. Therefore, such concepts as force majeure and hardship, which we usually consider exceptional remedies, might become regular in various situations. First of all, it is important to keep in mind while resolving such disputes and while planning the strategy such disputes, the purposes of the legal regulation, including the economic approach to law and economics. So one of the purposes of the regulations is to ensure a balance between stability and flexibility of contractual relations. Another is that the risks which derive from the pandemic should be equally allocated between the businesses, between the parties to international commercial contracts. Another purpose is that legal stability should be preserved anyway, rather than the chaos caused by the pandemic aggravated. And the economy should be restored from the crisis. Keeping in mind these purposes, I now proceed to past examples of dispute resolution, especially from the practice of arbitration, International Chamber of Commerce, and some others. The study of case law on force majeure and hardship shows that it is very important to clearly and well formulate the contractual contract clause, because when such clause exists in the contract, the arbitrators and judges first of all apply it, and only then the applicable law. The applicable law differs in many states, and however, in general, it is close to the concepts which are specified in the Vienna Convention of 1980 in Article 79 about the impediment beyond the parties' control, the sale of goods convention, and on the UNIDROIT principles on international commercial contracts, force majeure and hardship. Also, the courts formulate the same principles in many legal systems. The case law shows that, as a rule, debtor can be released from liability in cases where the impediment was not foreseeable at all at the time of the conclusion of the contract, and its consequences on the impediment itself could not be avoided or overcome. It is the debtor himself who should prove that he didn't assume this risk. Interestingly, there are cases which show that the debtor may prove that he was unable to predict the extent and period of existence of the impediment, which is relevant to the pandemic due to its unprecedented extent. As regards the references of the parties that the contract might become more burdensome, the general rule is that even if this risk was not foreseeable, the parties do bear it anyway. So the buyer bears the risk that the price of goods drops down, for example. The seller, on the contrary, bears the risk that the price will increase. And if there is lack of money, for example, the party cannot anymore obtain the loan, or the loan was terminated, this, as a rule, does not relieve the party from its contractual obligation. However, the parties may agree otherwise in their contract. Exceptionally, it is possible to rely on economic changes when, for example, an extraordinary depreciation of money occurred, or that the performance has become economically impracticable because the expenses of the party increased in an extraordinary way. Or, for example, there is a state act which directly prohibits the importation, exportation of goods, or payment in a foreign currency, and other way of payment is impossible. So, according to the principle of good faith, this is a reason for relief from liability of a party. However, the general rule, as the case law shows, is that an economic downturn does not amount to force majeure. It is considered to be an ordinary contractual risk. For example, in one case, the result during an ICC arbitration proceedings, the buyer referred to economic downturn that the contract force majeure clause was open. It provided some examples of force majeure events and added that any other reason beyond reasonable control of the party is also a force majeure. However, the arbitral tribunal found that other examples of force majeure, such as, for example, a war or natural disaster, had nothing to do with an economic downturn. So the tribunal confirmed that only if the risk related to economic events are expressly specified in the contract, only then the party may refer to them. The most, or perhaps one of the most important cases for, the subject which we consider now is case Global Tungsten Powder Corporation versus Lago Resources. In that case, the supplier referred to the drought, which prevented him from making the tungsten concentrate because it was not possible to anymore to obtain the water. However, the buyer objected that it was possible for the supplier to obtain water because it was possible to carry it in trucks many kilometers, though it would of course increase the cost of producing the goods tremendously, but the buyer said that it was the risk of the supplier. The arbitral tribunal recognized indeed the drought as force majeure because it agreed that the performance of the contract became impossible or economically impracticable. However, the tribunal confirmed that as regards the initial period of the contract performance, then the consequences of the drought could have been avoided by the seller if he had installed a more efficient water supply system, because the contract provided that the seller should attach commercially reasonable maximum efforts to overcome the problem. And so the tribunal decided that he did not. Therefore, the tribunal ordered the supplier to pay losses for non-delivery of the goods for the initial period of the drought. Many interesting conclusions were made within this case. Some of them are just confirming the general approach. For example, that if a party refers to a force majeure event, then the party bears the burden of proof that this event caused the impossibility of performance. Then another interesting conclusion is that if a party must produce and sell generic goods, then it must find a reasonable replacement for such goods, for example, which have similar or the same properties in the market, which means in the global market. Therefore, it is important for the sellers to specify directly in their contract that they will provide the goods only from specific sources rather than from the whole market. However, the arbitral tribunal agreed that it is unreasonable to expect that the party will use some unrealistic, impracticable, and uneconomical extremes to obtain goods, so that the expenses would be much higher than the, for example, the price of the contract. Another interesting conclusion is that, for example, if there was an unforeseen natural disaster and the goods were lost, for example, and perished, but it was because the packaging was defective, then the force majeure, the disaster, does not relieve the seller from its liability. Another interesting conclusion concerns the necessity of the notice of force majeure. As you know, in many legal systems and international documents, it is necessary for the party to duly and quickly notify the other party of force majeure. However, in the international arbitration case law, it was confirmed that there is no right to invoke force majeure if the party did not make a timely notice, only if the contract provides so, or only the other party shows that it suffered some damage due to such failure to notify. And of course, if the other party knew, was well aware of this disaster, of this event, then the notice is not important as a general rule. Another aspect of the problem is when the force majeure event is over. And it was already decided in some cases. If the fulfillment of obligations is now completely possible and unlimited, only then the force majeure event is considered to be finished, over, and done with. However, if the event is over, the period for fulfillment of obligations may be extended for some more days, because it's maybe necessary for the party to restore its business operations. So it's not on the next day after the the restrictions are non-existent. Not the next day may be necessarily the time to perform the contract, but the party may enjoy some additional period. It is important to pay attention to force majeure clause, and as some of you already know, ICC worked out a new version of model force majeure and model hardship clauses in March of this year. Now there are two different forms of force majeure clauses, long form and short form, which the parties may use. It is interesting that the force majeure event is defined in a way that it's not the same as impossibility to perform the contract. It's an occurrence of an event that prevents or impedes a party from performing its contractual obligations. So it's not necessarily impossible, completely impossible, but there is an impediment. And of course, if the consequences of the event cannot be avoided or overcome. There is also a list of force majeure events which the parties may add or may amend according to their particular wishes. And there is also an new ICC hardship clause. As you know, hardship means that it is still possible to perform the contract, but now it is much more burdensome. So the affected party may demand from the other party to renegotiate the contract to adapt it to the new circumstances. If the parties fail to agree, then they may apply to court or arbitration in some legal systems to terminate the contract, in some legal systems to terminate or amend adapt the contract. So there are two options in the clause: adaptation or termination, whichever is more preferable for the parties. Finally, I would summarize that in general, the parties are, in the existing case law, they are normally not relieved from their obligations. That rather high burden is on the party who invokes force majeure and hardship. And references to economic crisis are usually not enough as a rule to relieve the party from its liability. However, much depends on the particular contractual clause. Thank you very much for your attention, and you will find more in additional reading. Thanks.
Thank you very much, Dmitry, for this enlightening presentation. It was very interesting. And now Ella Omelchenko will present on impact of the COVID-19 on contracts, on construction contracts. Ella, the floor is yours.
To thank all the organizers to provide such a great opportunity for all of us, professionals, advisors, participants of different industries and markets, to share our views, to share our experience in such a turbulent times. I'm going to talk about the impact of COVID-19 on the construction contracts. And I will share the screen right now to demonstrate the presentation. So let me start. So the COVID-19 outbreak was declared a pandemic by WHO on 11th March 2020. And since then, national governments of countries, almost all countries, have started implementing measures and restrictions aiming to prevent the spread of the virus. These measures included bans and restrictions, both dealing with movement of people, goods across countries and even within one country locally. Inevitably, many parties are finding it increasingly difficult to, and sometimes even impossible to perform contracts which were signed before that outbreak. So where are we now? What we see currently is that national government kicked in emergency plans and measures as their immediate reaction and response to COVID-19 outbreak. State of emergencies and city lockdowns have been announced and implemented almost everywhere. Innovative measures such as quasi-quarantine regimes and so-called self-isolation regime have been implemented. For instance, Russian government permitted local governments to adopt and implement their own self-isolation guidance and regimes locally, depending by region. Major events have been postponed, such as Olympic Games, for instance. Production units, factories, offices, schools, restaurants, shopping malls have been closed. Now we see that some countries have started easing lockdown restrictions, and some restrictions are being relieved in respect of some industries or economic sectors. And currently we see that business is going to be back to normal in face of vaccine trials battling the virus. However, it is still too early to predict when we come to that stage. Since COVID-19 has largely destabilized global economy, all industries and sectors are impacted, and construction industry, of course, is no exception to that case. We see that both companies, owners, clients, and contractors experience difficulties, which are mainly common. And all these problems that companies and construction companies are facing now, they're quite urgent and require quite effective solutions in the new reality. Definitely the construction landscape is changing, and this new normal will likely stay with us even after the outbreaks recedes. Contractors and companies are seeking legal assistance and support to navigate through the new challenges that they're facing in this new reality. And I was going to show you some examples of recent queries, questions that we have been asked to advise on so far from many our clients. Public health is a primary concern, and major restrictions have been in the area of health and safety of employees. New policies, which should be now in place and adopted in various companies, they mostly concern regulations of shifts, requirements of temperature checks, disinfection of sites, tools and equipment, all scope of employment relation issues, and also requirements to comply or obtain some types of permits have changed due to travel ban, shutdown of airports, ports, and other transportation. These all factors actually impacted movement and relocation of workforce, and definitely impacted many construction projects. For instance, we know that those who arrived from certain countries should have waited up to certain period of time, up to 2 weeks, mainly before returning to work. And these quarantine measures definitely impacted availability of workforce in many construction projects. Second issue connected to the healthcare and safety issues, the key personnel. We all know that key personnel is now unavailable in some projects, and contractors are unable basically to comply with their obligation to keep key personnel, retain it at the site. Another issue which is of a great concern is whether or not the event which everyone's currently facing can be treated as a force majeure or material adverse effect event, or whether it will trigger change in law provisions in a contract. As Dmitry said in previous presentation, of course, all of this analysis should be undertaken based on the particular contract and governing law of the contract. However, there are many common features of the contract, and we'll talk about it later. Unscheduled business days, the effect how payment and delivery obligation have been changed. Additional requirements and guidance issued by government and local authorities, they definitely fall within definition of the laws in various countries, and definitely all such regulations need to be complied with, whether it's a matter of law or under some particular contract. Increasing demand on advice on business risk profile and alternative strategies in light of the new turbulent environment, including advice relevant to a particular sector of economy or industry, including increasing demand on advice seeking for in light of reputational and financial implications of business. We are also required to look at advice on structuring, or even better to say restructuring, of current project which haven't been launched yet, or which are scheduled to be launched later this year. Since many construction projects are being delivered using and based on FIDIC standards form of contracts, and these forms of contracts are widely recognized and used, in April, International Mediation of Consulting Engineers, FIDIC, has issued COVID-19 guidance memorandum for users of FIDIC standard forms of contracts. In appreciation of extraordinary challenge, which was brought by COVID-19 outbreak, the main purpose stated in this guidance memorandum by FIDIC is actually to help parties to consider solutions which could be mutually satisfactory and effective to both parties, just to keep the construction project live and avoid disputes, with a view to be focused on successful delivery of particular construction projects. In this memorandum, FIDIC addresses different likely scenarios which are a response to COVID-19 outbreak. One of the remedies and recipes for both the companies and construction companies to consider is an extension of time for completion. Contractors, which definitely suffered from difficulties in both attracting personnel due to travel ban or quarantine requirements, or other health and safety concern, they may request extension of time and FIDIC-based forms of contracts. There are, though, certain restrictions to be fully observed in order to be entitled to claim EOT. Namely, the event caused delay and shortage of personnel or goods must be unforeseeable. Well, I think that COVID-19 outbreak is definitely fall within such category. The contractors must diligently follow the procedure laid down by government authorities, which is also could be a requirement of the construction contract or any applicable law as well. These authorities delay or disrupt the contractor's work, which is also not difficult to meet, given the changes in the law that we are currently facing. It is very important to mention, though, that extension of time as a remedy itself, it is not a financial remedy, because whether or not the contractor could claim some financial compensation in addition to extension of time would depend on actual circumstances, and whether or not the contractor can establish its entitlement using some other clauses of the contract, or as a matter of law. Second big issue addressed in the guidance memorandum by FIDIC, or the second remedy, is a resulted from the change in law of the country. Change in law is one of the grounds that gives the contractor a right to request extension of time under the construction contract. But in addition to the extension of time, change in law also gives the right to claim change of the contract price. And there are conditions to the request and entitlement to change the contract price, which are the following. A change in law should happen after the commencement date. So it is definitely applicable to project where works have commenced. A change in law of the country in a contract has in a contract which is based on FDIC form, I should say, has a wide definition and various types of law, both at state and local levels, including various local and municipal laws, including decrees or guidances and etc. As FDIC points out in its guidance memorandum, emergency decrees and laws will likely fall within the broad definition of law provided in the FDIC forms of contract. Important, though, is to know that such law shall apply at location of the site where permanent works are to be executed. Third criteria is that the law must affect the contractor's performance of its obligation. Another criteria is that the contractors must demonstrate that it suffers delay and or incur or will incur additional cost as a result of change in law, which is also not able to demonstrate given the amount of burdensome regulations which are currently in place, at least in respect of the health and safety requirements to the employees, the construction site, and etc. And the contractors must give notice to the employer engineer, and this mainly will depend on the form of the contract. By the previous speaker, Dmitry, is the force majeure or exceptional event. Definitional and criteria of force majeure event are usually set out in the construction contract, including and those based on FDIC forms. We know, though, that COVID-19 may not necessarily be listed in the relevant clause, including the listing of pandemic, which is qualified right now. However, usually the list of FM-like event is not full, is not comprehensive, and is usually opened. So that said, the event, even if it is not listed in the clause of force majeure list of event, but it is subject to the criteria, it still may qualify as a force majeure exceptional event when passing the relevant test. So the test is the following. The event must be beyond the control of the parties, and COVID-19 meets this criteria. The party could not be reasonably provided against before entering into the contract. And again, it should be true in respect of COVID-19. Having arising, such party could not reasonably have avoided or overcome. Note the problem here, and FDIC brings our attention to potential argument to the set criteria. Namely, it recognizes that this part could be a problematic part of the test, as the one can argue that implementation of the relevant health and safety measures may make it possible to overcome the set COVID-19 measures. At the same time, the counter-argument could be that the government ban on construction activity in itself could not be avoided or overcome. The last criteria is that such event is not substantially attributable to the other party, which should be more or less true. in respect of COVID-19. So conclusion could be is that COVID-19 is likely to be treated as a FEM event, subject, however, to the provision of the contract and relevant local laws. Once COVID-19 passed the test and it could be decided whether it qualifies as an FM event or exceptional event. There will be a duty to notify the other party of such an event and a duty to mitigate. Usually, a FM event typically results in a cessation of the impacted obligation and gives an extension of time only. Usually, it also accrues to termination time clock. In order to apply all of these measures, of course, the based on FIDIC construction forms as an impact to COVID-19 outbreak.
Ella, I apologize.
There may also
for
be scope for
interrupting you.
contractual hardship clauses to be invoked. Again, consider local law entitlement, as Dmitry previously showed and demonstrated the examples. Performance, liability time, and cost relief may be available to contractual counterparty, but it again will mainly depend on the provisions of the contract itself. Response to COVID-19 itself or measures implemented by reason of COVID-19 outbreak may lead to restriction of the restriction on access, delay, or supply of equipment resources to be provided by the other parties. That may trigger variations to contract provisions. Of course, it is all subject to terms of the contract. And all of these measures may trigger entitlement to extension of time as well, or price adjustment, or suspension, or variation, and even termination in some of the cases. So suspension and termination is another example of other claims that could be considered. And all of these measures, they are could be available both at law and be set out in the contract itself. FIDIC also mentioned in the guidance memorandum that it is important for the parties to be reminded that there is a specific dispute resolution mechanism, such as dispute adjudication boards, and in case there is a dispute, the party may refer their dispute to resolution of that board. And another obligation to be reminded to the parties is that that all the parties shall timely comply with their communication obligations and shall provide notices in timely and due manner, and should keep contemporary records. That would help the parties to justify any of their claims in the future. As a result, what we also see in the practice and what we can discuss with different clients is the way how to deal and how to resolve the situation and how to keep the project to help both parties to overcome the situation. Mainly, if parties started a dialogue, they could first of all agree and acknowledge that COVID-19 outbreak has an impact on their relationship, and they could clearly state it in any additional correspondence or exchange of any or a correspondence or amendment to their agreement. And they may also agree on a specific COVID-19 suspension period, specifically designed to address the situation. So during this COVID-19 suspension period, party, first of all, could be obliged to put all their measures as a best efforts obligation to minimize possible consequences of such COVID-19 suspension period. And then can even specify the obligations which could be suspended. As an example, it could be obligations to keep personnel on the site, to deliver some goods. Even some schedules of delivery of the goods can be affected and reconsidered or rescheduled. And the parties may also consider which obligations are not affected and shall not be suspended. For example, all confidentiality obligations, IP obligations, and etc. Needless to say that since both parties suffering a lot from the situation with COVID-19 outbreak, usually the suspension period which the party may agree upon often goes together with some reasonable compensation of cost for that period. So it could be a combination of periodic payment that the client, the customer is required to pay to the contractor. Again, it depends mainly on the terms of the contract and the arrangement. However, all of this cost usually shall be reasonable, and we rarely see that the client would agree to compensate any profit or overhead. So it just really a cost that should be decided or agreed upon between the parties. And also some remobilization amounts, just in order to renew the works and bring it up to speed after all of these measures will be released. So the next obligation to be considered, to be included and negotiated at this stage is how to deal with demobilization and remobilization obligations. So it should be the contractor's obligation to demobilize or remobilize, again, subject to the terms and conditions agreed by the parties. And it was including upfront an agreement on compensation of reasonable cost, which definitely needs to be pre-agreed. Notices regime shall be specific notices regime in respect of this COVID-19 suspension period, and notices on demobilization and remobilization. So what we've seen so far is that the parties agree on a so-called like a long stop date for the suspension period, and then there might be even an option for additional suspension period or not. And then again, there might be other remedies triggered by one of the parties. And these remedies are the termination. So the party needs carefully consider, will they trigger the termination right, and as an option if COVID-19 suspension period has lapsed, for instance, and or additional period that party may agree is also ended. However, it is still not possible to resume the construction works. So all of these consequences of termination need to be negotiated in advance, including the consequences of such termination, whether it will go using the scenario of termination for convenience or the termination under different circumstances, but it definitely should be decided by the parties before and agreed. Other factors to consider and just to bear in mind is that usually, since many contracts with subcontractors are based on the back-to-back model to the main contract, so definitely it should be considered how to deal with a subcontractor's contract. Basically, it should be in the same manner as it would be agreed between the parties to the construction contract, which is being negotiated between the customer and the contractor. And also, other factors to be taken into account is whether or not a consent of any third party involved in the project must be obtained, such as, for instance, the consent of the financing organizations who provides financing, and finance documents may require the lender's consent for any amendments to the construction contracts which party may enter into and negotiate at this stage. So this is it.
Thank you very much, Ella, for this great presentation on the impact
This is the end
on construction. Could you hear me? Do you hear me, Ella? Thank you very much. Thank you very much.
Yes, I can hear you now, Shirin. Thank you.
Thank you very much. We seem to have experienced some connection issues during your presentation, but I would like to invite the audience to send their questions in the comments section, and we will be answering them at the end of all the presentations. Thank you very much, Ella. And I would like to now invite Alex to discuss on how COVID-19 has impacted his daily work.
Thank you, Shirin. So, hi, everyone, and thank you for joining us this sunny Friday afternoon. When I was approached by the organizers of this seminar to elaborate a little bit on the changes, how did coronavirus and all this pandemic affected our legal profession, day-to-day work, I simply took a list of paper and prepared a list, 2 columns of issues, how we used to live, how we used to work, and how we do it now, and apparently will do within next months, I should say. And at the end, I had 4 groups of issues, and would be glad to share it with you. I do believe that you, to some extent, face the same issues, the same problems, I should say. First group of issues, I call them changes in day-to-day work stream, day-to-day work. I should say that during last 2 or 3 months, my every day started with reading news in the legislation, the Russian legislation, federal, global, news in the legislation of each subject, each region of Russia, European, US, Asian regions, all those regions where our company, our group has interests or may have some interest. It was challenging, really challenging, tons of paper, hours of reading, lots of groups in WhatsApp, in Zoom and Facebook with my colleagues, special for labor lawyers, special for investment lawyers, in-house lawyers, and so on and so forth. More or less the same issues, problems we've been discussing and keep on discussing. What did the government mean by this on this paper and act? What did they want it to achieve? What they actually achieve? What does it mean for us? What can we do? What we have to avoid? Really challenging, I would say. Secondly, to reflect all this new stuff in the local papers, in the policies, in the rules, 24/7 of calls and mails from my colleagues, from financial department, commercial department, construction, and so on. Alex, what does it mean? Can we do this? Can we travel there? What does it mean, travel ban? Absolutely no travel, no business meetings, no business travels. Yes, guys, so far, nothing. Borders are closed to some extent. Well, no personal meetings. What does it mean for us? Working in the family office, you can imagine there are lots of questions that could be and should be addressed only in personal meetings. There is a question now. There is a question now because all our team was caught in various jurisdictions, cities, countries. We have to sort out these questions to some extent, to put on hold some questions. It's really challenging. It's really challenging. Last but not least, in this group, new clothes. literally new clothes. I had to put aside all my suits, shirts, to buy a bit of sport outfit, to buy some new jeans, t-shirts, you know. I really loved, to be frank. Another group of issues is relations with consultants and contractors, I should say. I had to immediately look for new expertise in new jurisdictions, in all other jurisdictions. Europe, US, Asia, Russia, specialists in compliance, specialists in regulatory, in tax, in customs regulations, banking regulations, all these spheres, all the areas specified in each and every jurisdiction. New time frames to be taken into consideration, new timing, new working schedule of courts, of the banks, of authorities, such challenging stuff as, for instance, KYC procedure, which used to take months. Now it's duplicated 2 times at least. New papers, new requirements, new documents. Please provide original of this and that document. But come on, guys, the borders are closed. Nevertheless, we have to. It's a new policy. For instance, in our Barclays Bank, please provide. Otherwise, the bank account is not open. Okay, I have to invite new ways to deliver the papers to you. New force majeure clause. It's the most interesting and challenging part of negotiations with all the, without any exceptions, with all the contractors. No one wants to bear this liability. This is the first time we used to write the word pandemia or something like that in the clauses before, but it's the first time we face it and have to react proactively. I should say, not retroactively, but rather proactively. Also, someone has to pay for delays in our work, for delays in our construction works. No one wants to pay. The contractors do want to get money for this delay. We do not want to pay for nothing. So it's a matter of negotiations. It's really fantastic. And you know, if some 6 months before I could have jumped on a plane and sit down in the conference room with all the parties involved and sit 24, 30, 40 hours with coffee and pizza, but to exit with well-drafted document. Nowadays, it's hours of Zoom calls, conference calls, emails. Waste of time, I should say, but I expect the borders will be opened soon. Third group, relations with colleagues. With colleagues, with reviewer, the greatest concern so far is again travel ban, and there is no possibility of personal meetings. I had to look for local employees in each year in their jurisdiction to join our team part-time somehow, not only advisors, but in-house lawyers to address very delicate issues, to take care of all these hours of Skype and Zoom calls, literally hours. I sometimes forget whether my camera is on or off. My earphones are always on, on AC/DC. So well, it's really challenging. And fourth group, I would say, not even comments, but rather a forecast. What we all hear is new reality, and we have to put up with it, because it's not a matter of weeks, months. I would say for at least next 12 months, we have to readdress our way of working. I can judge based on my colleagues and friends working in huge corporations such as Yandex, Pepsi, for instance. They're cutting their expenses, they're cutting employees, they're cutting lease expenses. They realize that the business can work quite productive without going to the office 5 business days per week. They are changing the schedule, and the employees will be going to the office 3-4 days per week, not more. They can operate remotely. It's a great cut of expenses, and they do realize this. Some of them take the pandemic as a good background for cutting expenses on employees. Good excuse, I should say, good excuse. Less business trips, as far as I can judge. Even when the borders are opened, some of my colleagues, for instance, literally afraid of traveling to Asia, for instance. to Hong Kong. It's unpredictable how it works to the States, also business there, but no one knows how it works. New visa problems and so on and so forth. So we seriously thinking about relocation of certain employees of various departments, financial, commercial, legal, and so on, to increase the substance in the jurisdiction where we have business interests. And lastly, new work-life balance. We have to find time for our families. We have to find time to sleep. We have to find time to do some sport. It's really important. Otherwise, we simply go mad. So good luck to all of us in this new reality. It's really challenging, and I personally enjoy it. That's it.
Thank you very much, Alexander. It's great to know that lawyers were able to quickly adapt to the new reality, to this new normal. Thank you very much for these insights. And I would like to now invite Tomas Vail to reflect on the previous presentations. Tomas, the floor is yours.
Thank you very much. Thanks for inviting me to speak. To reiterate the introduction that came nearly an hour ago, I'm Tomas Vail. I'm the founder of Vail Dispute Resolution. It's a boutique disputes practice focused on arbitration in the Russia CIS part of the world because I'm a native Russian speaker. I'd like to thank all of my co-panelists for their excellent presentations. It's been a pleasure to hear the different aspects of your practice and how they've been impacted by COVID, and particularly focusing on the contractual side of things. So I have the benefit of speaking last, and that gives me the opportunity to touch on certain issues that have been raised, and also to add some of my own observations with the benefit perhaps of the English law perspective and a little bit of the US or New York law perspective, as I'm qualified in both jurisdictions. There have been a lot of materials and literature put out on this subject as a result of COVID, and so there's a lot of material to synthesize. So I'll try to do that in the next, say, 10 minutes, because I know that we're running short on time. So first I'll make a few observations about English law. I'll tie that into some other comments that have been raised, and then I'll conclude with some thoughts about the future. So as some of us may know, but perhaps others are less familiar with the ins and outs of English law in particular, English law prides itself on taking a commercial approach to disputes and honoring the wishes of the parties as embodied in their contract. So from a policy perspective, this means that commentators, for example, BICL, the British Institute of International and Comparative Law, which has published some very useful materials on this that I'll be drawing from, they focused on avoiding an economic depression caused by the pandemic. And we heard some comments from Dmitry, which were echoing this principle. And in particular, we probably want to focus on the discussion of supply chains. As supply chains are increasing global, the disruption of one contract can disrupt an entire chain. And therefore, one dispute can lead to an entire chain of disputes. And I think we heard some comments from Alexander in this vein as well. At the same time as we have these pandemic-related disputes, we have other disputes arising as though, can you hear me still? As though they're caused by the pandemic, when in fact the pandemic might be a cover for other issues that have been going on already in the background. So parties have to be very astute in determining whether there's really a pandemic issue going on or if it's actually something else. So the kinds of disputes that we're talking about, we've heard already about hardship, force majeure. What we haven't heard so much about is frustration, unjust enrichment, and material adverse change. And I might touch on some of those principles a little bit in my comments. So these principles, they're well established both in the common and civil law systems, but we've not seen quite this kind of situation before. Some common issues, that is, some parallel issues in the past that might arise that are similar to this might be the SARS pandemic in 2006 and the economic downturn, financial crisis in 2007 and 8. And so some of the examples that I'll be touching on relate to those issues. And in fact, while I'm discussing the economic downturn, I saw an interesting slide in Dmitry's presentation talking about how economic downturn is not equivalent to force majeure. And I think that's probably generally supported under arbitral practice. I would point to an interesting example that I came across under New York law, which are two cases that relate to the 2008 financial crisis. So there were two cases in 2011, which were in the US courts under contracts governed by New York law. One was the Avalon case versus Wachovia Bank, where the economic downturn there was not considered to be a force majeure event. But there was a second case in 2011 where the clause in the contract specifically used the phrase, quote, change to economic conditions, unquote, as a force majeure event. And that was found to trigger the force majeure clause. So we have it, everything, as you noted and as others have noted, is very much dependent on the contractual language. So we may find that economic downturns are indeed covered by force majeure clauses if the clause has been drafted in that particular way. I'll note that force majeure and good faith, for that matter, these are not concepts that are included in English law as part of the as terms of art. They might be included in contracts, and therefore English law will recognize the contract and the provision that reflects that, but they're not reflected on their own in the common law, as opposed to, say, the principle of frustration, which I'll touch on in a minute. And Alexander touched upon the fact that there are new force majeure clauses being drafted at the moment, of course, in relation to this. So the language of those clauses needs to be very carefully considered. That's not new information, but it's worth emphasizing that every word, every phrase can drastically change the outcome of who has to bear the costs for any particular event. So those need to be reviewed specifically. Under English law, force majeure clauses are construed restrictively, meaning that any ambiguity will be resolved against the party seeking to rely on the clause. So that further underscores the importance of drafting things very carefully and clearly. So I've touched on those New York case law examples. Another kind of clause that could be included in a contract is a hardship clause. And we heard a little bit from Dmitry on that. But specifically under English law, of course, recognizes that. And that kind of clause will provide that in certain circumstances, parties will renegotiate, for example, the price, or they might include a provision that a third party can intervene if the parties fail to reach agreement on such renegotiation. And in my concluding remarks, we'll touch on kind of alternative dispute resolution methods, which are short of a full-blown arbitration or court litigation, which might allow parties to move forward without too much pain. So moving on to frustration, and I'll be touching on a point that Ella raised in her presentation as well. In contrast to force majeure, frustration is recognized as a common law principle, and it serves to discharge parties from their obligations, where, for example, the circumstances have changed so dramatically that performance of the contract is radically different to that which the parties had in mind and agreed. And that's a long-standing test under English law, where most recently in the Sea Angel case in 2007, not most recently, but that's the most recent case where this was kind of determined to be the key case for setting out the test, is whether the courts will look at the extent to which the risk for a certain event has been impliedly allocated between the parties. And we've heard from some of the previous presentations about this risk allocation principle, very important. So both parties will be released, but importantly, that does not render the contract void ab initio, and that's an important point to keep in mind. And that's, of course, a drastic result that both parties will be released. And on that basis, the English courts have taken the position that it's not to be lightly invoked, and courts are going to be looking very carefully. It's a high threshold to meet to allow the parties to be released from their obligations. I'll note also that under English law, there's legislation that allows the court to make adjustments to the parties' positions. This is under the Law Reform Frustrated Contracts Act of 1943. So this is similarly a way for a third party to intervene and modify the contract. And I think a thread that we'll hear throughout this pandemic and throughout my comments here is that parties might be able to find or will encounter different flexible approaches, more flexible approaches than they might in another situation to try to resolve their conflicts. So coming to one of the points raised by Ella in terms of emergencies notified by governments, I came across an interesting example where in Spain, there were government recommendations made where parties relied on the force majeure provision in relation to a contract during the SARS outbreak in 2006. So in Spain, there was a decision in relation to travel to Toronto, where the Spanish court issued guidance discouraging travel to Toronto during the SARS outbreak. And a party made a claim for a refund to a flight, which was upheld, notwithstanding the fact that the flight was not canceled, with the rationale being that someone with average diligence would heed the recommendations of the authorities and not endanger health by recklessly traveling to a place subject to such a health alert. So that's an interesting example, of course, on the much more personal and individual level, but I imagine that that principle could be extended, at least under Spanish law, or perhaps under other civil law systems, to extend more widely. I won't spend any time on unjust enrichment. Parties under English law tend to focus on the frustration argument. And then there's also the issue of material adverse change, which more commonly arises in finance documents and M&A documents, which allows parties to declare an event of default or exit from a transaction where there's been a fundamental change in a party's ability to perform its obligations. So these kinds of contracts are relatively rarely interpreted by courts, but in light of the pandemic, we may see more of these clauses being interpreted as the parties might seek to go to litigation or to arbitration. So we might see that, for example, the pandemic has raised economic issues for one business, which are not clear to its counterparty. For example, its company accounts are at the end of a term of a loan. And I think these kinds of issues will arise more commonly. And the ability of parties to rely on those clauses will turn on the specific language again, as we've mentioned before with relation to force majeure. English courts have held, in the context of a loan agreement, that a change in financial condition would only be considered material if it significantly affects a borrower's ability to perform its obligations for a long time, and the change is not a circumstance of which the lender was aware at the time of the agreement. And there's a similar approach in US case law, which describes such clauses in M&A context as a backstop protecting the acquirer from the occurrence of unknown events that substantially threaten the overall earnings potential of the target in a durationally significant manner. So that's a very brief overview of the English law position and tying it to some of the comments that we've heard from the other presentations. I'll briefly, in the next couple of minutes, and I'm still trying to stay very brief, some observations about the future. So it's notable that the UK has issued guidance on responsible contractual behavior in the context of the pandemic, and it's urging parties to be responsible and fair in relation to, say, impaired performance, extensions of time, claims of force majeure, frustration, change of law, and other claims. But that guidance is not legislation, and it does not override existing law or contracts. I'll also note that in commercial disputes, regardless of the pandemic, English procedure encourages parties to engage in mediation, and there are cost implications for the parties if they don't engage in mediation before bringing their dispute to the courts. Some jurisdictions have gone further than this. For example, France, Germany, and Singapore have adopted measures which we might refer to as breathing space. And in fact, the Bickel materials refer to that as breathing space. It's a helpful framework for thinking about these issues, which offers temporary relief to specified businesses and individuals which are unable to fulfill their contractual obligations because of COVID. For example, in Singapore, the legislation refers to parties, instead of bringing their cases to court, allow independent assessors to issue binding determinations on the basis of the financial condition of a party and trying to achieve an outcome that is just and equitable. So we see something which is not quite a full-blown dispute, but tries to allow parties to take their businesses and economic relationships further despite the pandemic. So to conclude, it's worth considering carefully if it makes sense for parties to go to a full-blown dispute, whether it's litigation or arbitration, or if it makes sense to find a middle way, which is to allow some breathing room, such as a negotiation or a mediation. And there are structures in place to allow those kinds of discussions to take place effectively. Courts are still operating virtually, touching on a comment from Alexander, and arbitrations are even more active in that respect, being able to adapt more flexibly their procedures to the current pandemic. And of course, the parties' consideration on how to best proceed will be driven by whether the underlying issues are actually pandemic related or they're a cover for something else. So I'll conclude my remarks there, and I want to thank my co-panelists for their illuminating presentations. Thank you.
Thank you very much, Tomas, for this interesting presentation and elaborating on alternative methods of dispute resolution. Now our session comes to its end. This webinar has been organized by Putilin Sipel and American University of Central Asia. I would like to thank all of our speakers for their insightful, enlightening, and very interesting presentation and stimulating discussions. Thank you very much. And I hope to see you in person one day after this pandemic is over. Thank you. Goodbye.
Thank you. Goodbye.